You set up a living trust. You funded it. You felt like you finally did something right for your family. And then nobody told you that some of the assets you put inside that trust, or worse, forgot to coordinate with it, could trigger taxes, invite lawsuits, or completely unravel the protection you paid to create. That is not a small mistake. That is the kind of mistake that costs your family years of legal headaches, thousands in unnecessary taxes, and the exact probate nightmare you were trying to avoid in the first place. I am Ben, and on this channel, Trip to Wealth. We teach the architecture of wealth, the kind of deliberate, structural thinking that turns scattered financial moves into something that actually protects the people you love. Today we are going inside the living trust conversation that most people never have. Not the should I get a trust conversation. That one is settled. Yes, you should. But the conversation that happens after, the one your attorney often skips, the one the internet gets half right. Which specific assets should go into your living trust, which ones should stay out, and what you should do with the ones that stay out so your estate plan still works the way you intended. This is not theoretical. These are real asset categories, real tax consequences, real court cases. And by the end of this video, you will know exactly what to do with each one. Stop for a moment. Most people who set up a living trust walk away with the same mental model. Put everything inside the trust. That sounds responsible. It sounds thorough. It sounds like the right move. And professionals reinforce it because they keep saying, fund your trust, fund your trust. What they forget to say is that overfunding, placing the wrong assets inside, can be just as dangerous as underfunding. Not fund everything. Fund correctly. That is the actual goal. Think about that. The problem is not whether you have a living trust. The problem is that most people fund it based on a general rule rather than an asset-by-asset analysis. And when you apply a general rule to specific financial instruments, you get specific financial damage. Taxes you did not owe, lawsuits that now name your trust, protections that disappear the moment you retitle something incorrectly. That is the trap. The belief that more is always safer. It is not. Precision is safer. Let me be direct about that. So here is the reframe we need before we go through each asset. The goal of a living trust is not to own every asset you have. The goal is to ensure that every asset you own transfers the right way, with minimum tax friction, maximum control, and maximum protection for your beneficiaries. Sometimes that means the trust owns the asset directly. Sometimes it means the trust is named as a beneficiary. Sometimes it means the trust does not touch that asset at all. 3 different outcomes, all correct, depending on the asset type. That is the entire playbook. Now I am going to walk you through each one. Asset 1. Retirement accounts, your 401k, your IRA, your 403b. Do not place these inside your living trust. Here is why. Retirement accounts are already trust structures. The IRS built them that way. When you change the owner of a retirement account from yourself to your living trust, the IRS can treat that as a full distribution, meaning every dollar in that account becomes taxable income in the year of the transfer. If you have $400,000 sitting in a 401k, that is a $400,000 taxable event. That is not a planning strategy. That is a catastrophe. What you do instead is keep yourself as the owner and use beneficiary designations to coordinate these accounts with your estate plan. Name your spouse as the primary beneficiary. Then name your living trust as the contingent beneficiary. That way, if your spouse is no longer living, the trust steps in and controls how that money flows to your children or other heirs, protecting it from creditors, divorces, and irresponsible distribution. There was an actual Supreme Court case where a daughter inherited her mother's IRA worth over $450,000 directly, and the daughter's creditors took it. A properly named trust as contingent beneficiary would have prevented that entirely. Asset 2. Health savings accounts. Your HSA is a different animal from your 401k, but the rule is the same. An HSA can only be owned by an individual. It cannot be transferred to any trust, including your revocable living trust. The moment you attempt to retitle an HSA into a trust, the tax protections disappear immediately. The entire account loses its tax advantage status. That is not a maybe, that is the law. What you do is name beneficiaries directly on the account. If your spouse is the named beneficiary, they inherit the HSA and all of its tax benefits carry over seamlessly. They can treat it as their own. If anyone other than your spouse inherits directly, the tax benefits end at your death, and the account is treated as taxable income for the beneficiary. So the structure is the same as retirement accounts. Spouse as primary beneficiary, living trust as contingent beneficiary. The trust does not own it. The trust steps into the picture only when needed, controlling distribution with the guardrails you designed. Before we go further, drop one word in the comments right now. Your single biggest blocker when it comes to getting your estate plan right. One word. Fear, confusion, delay, cost. Whatever it is, drop it. Now, let's get into the remaining assets. And this is the part most people never reach. Asset 3, annuities. This one catches a lot of people off guard, especially if you are 47, 52, 58 years old and you have built a meaningful annuity over the years. Annuities feel like they should go into the trust. There is real money there. You want to protect it. But here is the structural reality. An annuity is itself a trust-like agreement. There is already a custodian managing those assets on your behalf, which functions the way a trustee does. When you retitle an annuity into your living trust, the insurance company can treat that as a surrender event. Every dollar of deferred gains inside that annuity becomes taxable right now. If you have $200,000 in an annuity that has grown $80,000 in deferred gains, you could owe taxes on that $80,000 in the year you make the change, for no benefit whatsoever. The structure is identical to retirement accounts and HSAs. You own the annuity individually. Spouse is the primary beneficiary. Living trust is the contingent beneficiary. The trust does not own your annuity during your lifetime. It inherits it, and that distinction matters enormously. Asset 4, life insurance policies. Life insurance already avoids probate. That is the key fact. Because it passes by beneficiary designation, there is no reason to place a standard life insurance policy inside your living trust. Doing so adds complexity without adding protection. The right move is to name your spouse as the primary beneficiary so the death benefit transfers cleanly with no tax consequence. Then name your living trust as the contingent beneficiary, so if your spouse is no longer living, the trust controls how those proceeds flow to your heirs. The trust protects the money from your beneficiary's creditors, from divorce proceedings, from substance abuse situations, from poor financial decisions. It puts guardrails on the distribution instead of handing a 24-year-old a lump sum check. Now, if your estate is very large, we are talking estates above $12 million, or for married couples above $24 million, there is a separate tool called an irrevocable life insurance trust that can remove the policy proceeds from your taxable estate entirely. But that is a different conversation for a different video. For the majority of people watching this, own the policy individually, name the trust as contingent beneficiary, and you are covered. Asset 5, vehicles, cars, trucks, boats, RVs. Most people assume these should go directly into the trust because they want everything protected. Let me be direct about that. Keeping vehicles out of your trust is the protection. Here is why. When a vehicle is involved in an accident, and it is titled in your living trust name, the plaintiff's attorney will name your trust as a defendant. That means they now have a roadmap to every asset your trust holds. Instead of protecting you, titling that vehicle in the trust has just handed them a complete inventory of your wealth. Beyond liability, vehicles are typically easy to transfer at death through state DMV processes. Many states allow transfer on death titles. There is no probate risk to manage. And practically speaking, insurance companies get confused insuring vehicles titled in a trust. You will spend time and money shopping for coverage and educating insurers, and in the end, the complexity buys you nothing. Keep vehicles in your personal name. The exception is collectible or high-value vehicles over $100,000 where the trust's distribution control has more value than the complication it creates. For your everyday car at $20,000 or $35,000, the math does not justify it. Asset 6. Regulated assets and professional licenses. This one is less common, but it matters significantly for certain viewers. Professional licenses, liquor licenses, specific business permits. These assets carry legal ownership rules built into the regulations that govern them. You cannot simply retitle them into a living trust without first understanding whether the governing body allows trust ownership. If you do it incorrectly, you may invalidate the license entirely. A liquor license that gets invalidated because of an improper transfer does not just create a paperwork problem. It can shut down a business. The rule here is simple. Do not transfer regulated assets or licenses into any trust until you have confirmed with the issuing authority, an attorney, or both that the transfer is permissible. This is a do not touch until verified category. If you have these types of assets, you know what they are. Get proper guidance before you move anything. Asset 7. 529 college savings plans. If you are a parent or grandparent with a 529 plan, pay attention here. A 529 plan has a very specific ownership structure built into the account itself. You are the account owner. You name the beneficiary, typically a child or grandchild. That ownership structure means you cannot title the account into your living trust during your lifetime. But here is what makes the 529 different from everything else on this list. You already have the control you were looking for. As the account owner, you can change the beneficiary at any time or withdraw the funds yourself. The control that a trust would give you is already baked into how the 529 works. The concern is what happens when you die. The answer is straightforward. Name a successor owner on the account. That successor owner steps in at your death with no probate, no trust involvement required. You can actually name your living trust as the successor owner. During your lifetime, you hold full control. At death, the trust steps into the owner position and manages distribution exactly the way you intended. Check every 529 account you own and confirm that either an individual or your living trust is listed as the successor owner. That one step keeps the account out of probate completely. Now let me tell you what this whole list actually reveals. Because the pattern here is not really about individual asset types. The pattern is about a mental model you were never taught. Most people approach estate planning thinking about tools, trusts, wills, policies. But the real architecture is about coordination. How does each asset flow? Who controls it? When does the trust step in versus when does a beneficiary designation do the work? When does keeping an asset out of the trust actually create more protection than putting it in? That is not discipline. That is not a matter of being organized enough or motivated enough. That is architecture. And nobody sits you down at 42 years old and walks you through it. Nobody teaches this in school. Your HR department did not cover it during benefits enrollment. And the attorney who set up your trust may have handed you a document without explaining that how you coordinate the assets matters as much as whether you have the document at all. Not your fault, but your responsibility. So here is the diagnostic question that tells you whether your current setup is built or just begun. Look at each of the 7 asset categories we covered. For each one, can you answer 2 things? Who is the primary beneficiary and who is the contingent beneficiary? If your living trust is properly positioned as the contingent beneficiary on your retirement accounts, HSA, annuities, and life insurance, And if your vehicles are in your personal name with your trust noted in your final instructions, and if your 529 accounts have a successor owner designated, then your estate plan is coordinated. If you cannot answer those questions with confidence, you do not have an estate plan. You have a document. One rule: your wealth architecture should be able to transfer your estate cleanly without your family needing to figure anything out in the worst moments of their lives. If they would have to scramble, it is incomplete. Incomplete is not safe. My friend, you have two choices right now. You can close this video and go back to assuming that the trust document in your filing cabinet is enough, or you can take 20 minutes this week and go through each of the 7 categories. Pull out your accounts. Look at the beneficiary designations. Ask one question for each. Does this transfer cleanly, the right way, to the right people, with the right protections, if something happens to me tomorrow? That is the entire exercise. 20 minutes, one category at a time. Not overwhelming, just honest. And if you find gaps, and most people do, now you know exactly what to fix and why. The architecture is not complicated once you see it clearly. The assets that go inside the trust, the assets that stay out but name the trust as contingent beneficiary, the assets with their own built-in control structures that just need a successor designation. 3 categories, 7 assets, 1 coordinated plan. That is not luck. That is not hope. That is wealth built with intention. And when it is built that way, it does not just protect your money. It protects the people waiting on the other side of every decision you make today. One decision: build the architecture or leave the gaps. Irreversible wealth does not happen by accident. It happens because someone at some point stopped and did the work.